Hi everyone, happy November now. I want to bring you a few cases from the first part of the month. First up is a COVID-19 and employment-related case called Bedard versus the City of Los Angeles. There, the plaintiff was an LAPD officer and she would not comply with a COVID-19 vaccination mandate and was subsequently fired after a review board for the PD looked at it. They awarded her some back pay for a due process violation but upheld the termination. Trial court agreed with the termination and the back pay decision by the board. Court of Appeal took a look at this and affirmed the termination for noncompliance with the COVID-19 vaccination requirement, topic we've been hearing more and more about as the vaccination requirement decisions and employer terminations that result from that have been making their way through the appellate system. And this one, the requirement was upheld. There was in the city's order requiring vaccination a religious or medical exemption clause, but she didn't base her refusal on either of those grounds, and thus the Court of Appeal upheld the decision for termination. Next up, a matter involving a physician distributing narcotics in the case of U.S. v. Pham, a Ninth Circuit decision where the doctor wanted to withdraw a guilty plea for distribution of controlled substances. The statute he challenged is silent as to the definition of when distributing narcotics is authorized, but there are related regulations that say it has to be for a legitimate medical purpose. The Ninth Circuit here rejected the request to withdraw the guilty plea and ruled that the pills were distributed, quote, outside the usual course of professional medical practice and without a legitimate medical purpose. So in essence, he couldn't withdraw the guilty plea because the regulations define what the statute is silent as to. Next up, we've got a minimum wage executive order challenge called Nebraska v. Sioux, interestingly found in the Ninth Circuit. Even though it's a Nebraska-based case, there were actually a number of states that challenged this executive order issued by President Biden, which required federal agencies to require their contractors to pay their employees a minimum of $15 an hour. A number of the states, as I said, challenged that executive order, and here the Ninth Circuit ruled the order was in fact beyond the president's authority and it violated the major questions doctrine, so they could not, by executive order, require agencies to require contractors to pay their employees $15 an hour. I want to tell you about a arbitration procedure type case. This one is in an senior care center called Ortiz v. Elmcrest Care Center, LLC, and in it, a California Court of Appeals found an interim award issued by an arbitrator, which had found the estate of a deceased resident to the care center did not prevail on any claims. It was an interim award. The estate challenged that, saying the arbitrator overlooked certain pre-death claims, and this led to a second interim award granting the estate some damages. That was in turn challenged by the care center, who claimed that the original interim award was final. The trial court, when it got its hands on it after the arbitration, found, in fact, that the first award was, in fact, final, and the estate appealed from that. The Court of Appeal, Second District, found the interim award originally was not a final award, as it had explicitly reserved jurisdiction for further consideration. In the end, the estate was awarded the pre-death damages because the interim award was just that. It was interim, and that allowed the arbitrator to go back and add the additional damages. That's it for the first week of November. Look forward to updating you on subsequent weeks here as the Courts of Appeal and Ninth Circuit continue to provide us with more and more rulings for you to consider. Thank you.